This hour, we're going to be in Utah for the End Her Suffering murder case of Meggan Sundwall. Sundwall, a registered nurse, is accused of conning her friend into believing that she was terminally ill and poisoning her with a fatal dose of insulin so that she could collect on her friend's $1.5 million insurance policy, which she believed she was the beneficiary of. Now, her friend, Kacee Terry, was completely healthy. Last week, Sundwall was in court asking for bail. So we're going to get you caught up now on that hearing. Right now, the state is challenging her motion for bond.
The state opposes bail in this case under Utah Code 77-20-201, subsection C. The preliminary hearing established substantial evidence supporting the charges, and the defendant presents both a significant flight risk and a danger to the community such that she should not be eligible for bail. I'll start by talking about the severity and nature of the charges. As the court's aware, the defendant is charged with aggravated murder. This is Utah's most serious offense. Courts in the state have historically denied bail in such cases. I am not personally aware of any aggravated murder defendant ever being released on bail before. The potential penalty of life without parole, even though the state has removed the death penalty as a potential, there still is the potential penalty of life without parole, which provides the strongest incentive for Ms. Sundwall to flee. Ms. Sundwall also faces a charge of obstruction of justice. The evidence at the prelim has already shown that she attempted to interfere with this very investigation. The combination of the offense's severity, her history of deceit, her financial desperation, and her manipulative conduct makes her both a profound flight risk and an ongoing danger to the community. I'll talk about the flight risk now. The defendant's personal history and current circumstances establish a clear risk and likelihood of flight. She has a record of dishonesty in employment. In fact, in 2024, she was fired from her nursing position with IHC for falsifying time cards and lying about it. Her corrective action form explicitly noted that she failed to meet the standards of trust, integrity, and accountability that IHC had because of that lie. Her work history and conduct are relevant for Your Honor to consider under 77-20-205-8BD. The issue of financial crisis is very pressing in this case. Her husband is already selling their home and their car. Her parents have encumbered their home with a $30,000 loan just to retain private counsel. Jail calls have confirmed that, or at least what they're discussing, is that her contract with Mr. Williams only extended through the preliminary hearing, and the family has evidently been told that they cannot afford him going forward unless they work something different out. So she is under immense financial crisis right now. She's lost her professional license. Doppel, a representative of Doppel, came to the jail and suspended her nursing license, cutting off her career path and income. She has a history of drastic responses to financial stress. Obviously, the case we're here for, when previously under financial strain, she murdered a mentally ill friend in hopes of securing a $1 million insurance payout. She demonstrates a willingness to skirt rules. On jail phone calls, she has conspired with a friend, Catherine, who incidentally is somebody who wrote a character letter on Meggan's behalf, to launch a GoFundMe campaign, despite that platform having rules that explicitly bar fundraising for violent crime defendants. Jail calls have revealed that she intends to ask Mr. Williams to rewrite the campaign to evade detection. And what Catherine even remarked is she wished she could just post that Kacee was a lunatic. Kacee, of course, being the murder victim in this case. This pattern demonstrates resourcefulness, manipulation, and desperation on behalf of the defendant. If released, she has every motive and ability to abscond, and no condition of release could ensure compliance. Judge, she's also a danger to the community. I understand, and I've reviewed all the letters that the court has been given as well. People from, all parts of her life that are coming out and supporting her and vouching for her character. But what's truly astonishing about this case is that the victim herself considered the defendant a close friend, and Meggan deliberately exploited and weaponized that trust against Kacee. Meggan is calculated and engages in financially motivated violence. This case was not an impulsive act. It was premeditated killing. It was driven by greed. Now that her financial situation is even more acute, the risk of similar conduct has only increased. The defendant is manipulative. Letters of support or character references cannot be taken at face value here. The defendant has an ability to manipulate even her closest relationships, as we saw with Kacee, who she pretended to be best friends with over the course of many years. Indeed, any letters of support or character references on the defendant's behalf must be understood in context. The victim herself believed the defendant was trustworthy and loyal, yet she became the very target of her scheme. This case is a chilling reminder that those closest to the defendant are not necessarily safe. Her friendships and relationships are tools that she uses for manipulation when it can serve her, not genuine bonds that restrain her conduct. Any assurances about the defendant's good character from friends or family must be weighed against this reality. She manipulates relationships to her own advantage. If Kacee Terry, which is her actual last name, not Kelly, as defense repeatedly put in their motion, which I understand was a mistake, but I just wanted the record to be clear that the victim's name here is Kacee Terry. If she was alive, I would guess in all likelihood she would be front row center here in this courtroom supporting Meggan herself. Meggan's conduct shows that when under pressure, she's capable of drastic acts against those around her. The community cannot be protected if she is released, because frankly, she's unpredictable when she's backed into a corner, especially financially. Your Honor, this case presents a particular intersection of flight risk and danger. It's uniquely alarming because flight risk and danger converge here. Meggan is not only motivated to flee, but also has demonstrated that escalating financial and personal pressures drive her to extreme, unlawful, calculated, and even lethal actions, as we see here. She is exponentially more financially desperate now than at the time of the homicide, magnifying both risks. Obstruction of the criminal justice process is also a factor that the court can consider under 77-20-205-4B4. And that's whether a defendant will obstruct justice or attempt to if released. This defendant has already been charged and bound over for obstructing justice. The preliminary hearing established that she repeatedly lied to law enforcement. She deleted hundreds of text messages with the victim, which covered insulin, suicide, and the supposed life insurance policy. These were all the very evidence that demonstrated her motive. These deletions were calculated efforts to conceal her plan and mislead investigators. Given this proven history, there is no reason to believe she would suddenly comply if released. On the contrary, the risk of further obstruction is exceptionally high, and no conditions the court could impose could mitigate that. The seriousness of the charges, the maximum potential penalty, her demonstrated pattern of repeated dishonesty and manipulation, even in a work context, her escalating financial crisis, her willingness to resort to extreme and lethal measures under pressure, and her proven obstruction of justice all weigh decisively against release. For these reasons, in addition to the letter which the court received from the next of kin of the victim, stating her reasons for not wanting the defendant to be released, for all these reasons, the state respectfully requests that bail be denied. If Your Honor is inclined to provide bail of some sort, I would like to speak further about what some of those conditions might be, but for now my argument is she should be held without bail.
Thank you.
Thank you.
Mr. Williams.
Thank you, Your Honor. It's always a little difficult, if not frustrating, to learn what references the state might make for the very first time when they take the podium. I try to do a memorandum so that issues or questions might be fleshed out. Of course, come here without knowing that they're going to cherry pick some jail calls. I don't even know if I've received those in discovery, but I just want to let the court know that some of those things that were mentioned, I can't rebut right now or put in any context for you because they've never been brought up, except for her employment. I'll tell you, she worked as a teacher at UVU after what we believe is the false time card issue that got her fired from the job that she had before that. When she was arrested here, she was teaching at UVU. I don't really want to tit for tat all of that stuff. This is a remarkable situation. I don't want to restate what's in the memorandum either. That's the purpose of a memorandum, is so we don't have to. But thematically, I'll speak to it. It begs the question entirely when the argument to hold someone pretrial is that they're guilty of what they're accused of. Of course it does. So the right to bail has always been the backdrop to any crime of any alleged seriousness. I think there are victims of plenty of crimes that would suggest that it's just as serious, if not worse, than this case. Seriousness is important, I submit to you, Your Honor, in relation to the facts associated with the seriousness and not just the level of offense. This is the same, by the way, as a rape of a child or sodomy of a child, 25 to life. So there's lots of seriousness, and we manage people all the time, and we use the statute for guidance. And as you know, the statute's pretty significant in terms of what a court must find factually in order to deny somebody bail, to hold somebody without bail. It's got the strongest, as you know, burden of proof that exists other than beyond a reasonable doubt at trial. I've cited some of the law that speaks to the seriousness and importance of fact-finding in relation to the features of a release circumstance. You know that as serious as the government claims that the criminal offense was, it is just as isolated as you can ever imagine coming before your court. In other words, no one sprayed any house with bullets or, stabbed somebody at a campfire. The dangerousness is inherent in the utterly isolated circumstance and can only be, and I've been trying to think about how to carefully reference the fact that the person who would have been in danger, of course, is deceased. Our position is, of course, that Meggan didn't do it, and that you heard about years and years and years of working with Ms. Terry, and I'm sorry if I made, I guess if you don't file a memorandum, you don't have to worry about typos, but I'm familiar with the facts of the case and mean no disrespect if I have made typos in my memorandum. But to present her with the sort of references that were made, I submit is really somewhat disrespectful. I mean, if you're going to listen into phone calls and talk about hundreds of people wanting to help someone because they think she's wronged and they know her well, then I think that's a sign of desperation. There's nothing in her criminal history, of course. There's nothing in her history in this community with this community that she would be released into that suggests any danger to anyone.
All right, we're going to take a break here, but before we do, I have an update on a trial that we've been covering coming from Florida, the pregnant mistress murder trial of Jose Soto Escalera. The state rested earlier today. The defense rested as well without calling any witnesses, including Soto Escalera, who decided not to testify in his own defense. He is accused of killing his mistress, 23-year-old Tanya Wise, and their unborn child back in 2018. But the defense points to other men in Tanya's life as possible suspects. Today, jurors heard a translation of a call between the defendant and his nephew, where Soto Escalera appears to be talking about covering up Tanya's murder. Take a listen.
And since she disappears like that for a couple of days, no one is going to be looking for her. I already took 2 baths when I got to her house, and I bathed this morning. I bathed. I cleaned my hands with the cleaner, the one for breaks, because I had gloves and everything just in case.
Did you see the blood?
Huh?
Did you see blood? Did you see?
I had it all over the clothes, but without the evidence, they can't do nothing. If something happens, no one saw the bag.
Again, closing arguments are set to begin tomorrow morning. We'll bring those to you live right here on Court TV. All right, we're going to take that break now. Coming up, we're going to continue with the hearing in the end her suffering murder case of Meggan Sundwall. The former nurse is accused in the poisoning death of her good friend by encouraging her to take a lethal dose of insulin. Her alleged motive? To cash in on a $1.5 million insurance policy. Up next, the defense contends that Meggan did not do it. Keep it here on your front row seat to justice.
Young mother found brutally murdered.
Now the victim's boyfriend, a married father of 4,
is charged for the murder of his alleged mistress and her unborn child.
The pregnant mistress murder trial. Live coverage today, only on Court TV.
Tonight on closing arguments, the ex-boyfriend of Wendy Adelson and the explosive police interview. What he told police and what could be next in the Adelson saga.
Closing arguments tonight at 8/7 Central on Court TV.
All right, folks, we're going to get you back to court in just a moment. But first, I want to bring in our guest for this hour. Joining us, criminal defense attorney, former prosecutor Marsha Minot. Marsha, great to see you as always. Thank you so much for joining me here on the program. I'm going to get your opinion on what we're seeing. Essentially, this is a bail hearing, right? The judge gets to consider a few things: seriousness of the crime, the criminal history of the defendant, flight risk, safety for the public, the normal things you get to consider. They consider it in Utah as well. I thought the state made a very clear and cogent argument. The defense, not so much, sort of rambling on about, problems with the evidence being used by the state as far as at this hearing. What do you make of what we've seen so far?
Well, it's clear that the defense was blindsided by jail calls that his client had that he wasn't aware of until they were thrown up by the state in this hearing. I'm not a fan of using non-related factual circumstances, such as you're a liar on your job application or you lied on your time card, so there you go, now you are a murderer. But I do understand that the court has to consider, in some states they call it the state case that determines it. In Georgia, it's called the Ayala factors, and these are factors that the court has to consider, and it's clear that this court has to consider those. That's flight risk, threat to the community, if you're going to reoffend while you're out on bond, or if you're going to tamper with witnesses and the process. If the court finds that, then the court must deny bond. But not because you're charged with murder doesn't mean you're not entitled to bail. Bail is not punishment.
Fair enough. Now, the state mentioned that, as far as they know, no one charged with aggravated murder had been released. Let's start right there. The idea, we know that people have a right to bail, but most states, if you're charged with serious aggravated murder, the chances for bail are almost slim and none.
Well, they are. It's tough because the court is going to always be concerned about threat to the community when you're talking about murder. You're talking about taking the life of someone. However, there are cases where bail is granted while the person is actually out on bond, because remember, the court has resources. They can put you on an ankle monitor. They can put you through what's called pretrial services monitoring. They can put you on a 24-hour curfew. There are things that the court can do, and with technology now, Michael, they can keep up with you. Trust me. If you leave that house or pass that threshold, they can tell exactly where you are. So they can grant bail now because we have a whole lot more technology to keep the community safe when you have a charge such as murder.
Fair enough. And we've seen some scary defendants. This one I find to be extremely scary. We'll talk about that in a minute. I want to get folks back into court right now for that bail hearing for defendant Meggan Sundwall. The defense is continuing their argument for why Sundwall should be granted bail.
It is just as isolated as you can ever imagine coming before your court. In other words, no one sprayed any house with bullets or, stabbed somebody at a campfire. There's the dangerousness is inherent in the utterly isolated circumstance and can only be, and I've been trying to think about how to carefully reference the fact that the danger, the person who would have been in danger, of course, is deceased. Our position is, of course, that Meggan didn't do it, and that you heard about years and years and years of working with Ms. Terry, and I'm sorry if I made, I guess if you don't file a memorandum, you don't have to worry about typos, but I'm familiar with the facts of the case and mean no disrespect if I have made typos in my memorandum. But to present her with the sort of references that were made, I submit is really somewhat disrespectful. I mean, if you're going to listen into phone calls and talk about hundreds of people wanting to help someone because they think she's wronged and they know her well, then I think it's a sign of desperation. There's nothing in her criminal history, of course. There's nothing in her history in this community, with this community that she would be released into, that suggests any danger to anyone, any harm at all, really. I think that the people that you might talk, there's been desires to go fund me in this case from the very first minute, because these people care for her and because these cases are expensive and because everyone is desperate to get her well defended, as they see as well defended. I'm not vouching for myself, but my point is how could that be held against somebody that they're trying to defend themselves? That supports the notion that she's in it to win it. She's not desperate. She's got a whole community. She's got a legal team. She's got a criminal justice system forward. We all know the prelims is the low point for every defendant in a case. She's not going anywhere. And so, again, I don't want to tip or tat those arguments, but I submit that everything is in favor. I honestly, as I wrote in my memorandum, had to sit and wait for the government's arguments because I couldn't think of one. I really couldn't think of any way that the risk and the dangerousness features of your decision in a detention, any way that every box wasn't checked in her favor. Again, obviously it's a serious charge, but even I cited the law that should be obvious, right, is that you can't, it begs the question to focus overly on the offense level, right, versus, or kind of offense versus the facts associated with that offense. And this is a remarkable circumstance where I believe the facts associated with it are so isolated and of such a nature. I mean, even what she's alleged to have done was never a threat to anyone else. You know, this obstruction is, again, isolated to the absolute contours of the events of the case.
All right, we do need to take a quick break. When we come back, we're going to get you back to more of that bond hearing for Meggan Sundwall and the end her suffering murder case going on in Utah. So keep it here in your front row seat to justice. Welcome back to Court TV Live. I'm Michael Ayala. Back to Utah now for a hearing in the end her suffering murder case of nurse Meggan Sundwall. Prosecutors say Sundwall convinced her friend, 38-year-old Kacee Terry, that she had terminal cancer, even though she was healthy, and killed her with a lethal dose of insulin. Investigators say Sundwall believed that she was the beneficiary of Terry's rumored $1.5 million life insurance policy. Sundwall was in court last week for a bond hearing, so I want to take you back there now.
So it's an interesting.
We'll hear from Ms. Hunt after that.
Perfect question, and it has that same interesting component because really, there's nothing. She's not harmed, right? And there doesn't suggest she'd be a risk of flight. And she doesn't suggest she would harm anybody. Nothing about her life. I mean, she could, however, maybe, and even in reference to the seriousness of the circumstance and a respect for the justice component of it, she could be on home confinement. If there's really any kind of risk, we manage, as you know, people on home confinement who are accused of going out and hurting people, children. That would monitor a risk. If there's ever an argument that somebody's so desperate that if you let them out, they're going to run away because they think they're going to lose their trial, we do manage people on risk, of course, by ankle monitoring. And in my experience, Judge, honestly, I don't remember anyone fleeing in 33 years. But this is also her place. I mean, I know that the state has said all these people are gullible. They're all just wrong about Meggan. She's fooling them all. I don't think that's the case. This community wants her out. This community will support her. And you think she's going to take off and leave all these supporters hanging so we can put her in her house if we need to, and they can come visit her and help her? And if they want to try to help her defense, I think that's okay. It's not sinister. You could, there's other conditions. She'd want to work. Of course, she's not going to be a nurse, but you can do lots of things to work from a home, especially with the sort of support that she does have. She'd have to get a job. She can't be a nurse. If you were to confine her to a home, she'd still be able to figure out. She's a family. These children are suffering. Her husband is suffering, and she could do societal good, even under, like I say, conditions of home confinement. And I understand that, right? I understand the enormity of a decision with these sorts of charges. It is just about as unique as I could ever imagine when you apply the law, and the fact finding that's required to the circumstance. Again, it's hard to suggest conditions because they don't really appear to be necessary, but it would be, a show of respect for the seriousness, for instance, for home confinement. It would allow, Judge, we all know it is exponentially more difficult to defend your case from jail. Home confinement would allow a remedy for that. It would allow her to be with children, her children. It would allow for her to work, to figure something out to work, and of course work hard with her team to prepare her defense, while mitigating any risk. I mean, I just can't imagine, Your Honor, think she would hurt her family if she was on home confinement. But and any flight, where would she go? I don't really know. And you have all the facts in front of you that she would let down her entire community. Those letters were ones that we chose. They weren't all the ones that came in. And you can see them here in court. Do you have other questions along those lines?
I don't.
Any other questions in terms of facts that you would want to know in relation to your fact-finding requirements?
I don't.
Your Honor, thank you.
Thank you. Ms. Hunt, I have the same question for you. I haven't made my decision. But if Ms. Sundwall were to be released, what do you think would be appropriate conditions?
Judge, I don't believe there are appropriate conditions that would guard against what the state is concerned about. I certainly didn't mean to suggest that everybody sitting in this courtroom has been fooled or lied about Ms. Sundwall's character. People are capable of behaving in one way toward people and in a completely, Your Honor sees defendants all the time that their family and friends are utterly shocked that they committed the crimes that they, later plead to or are found guilty of. The same is true here. And in fact, character is only minimally relevant here. Probable cause has been established that she murdered the victim in cold blood. She'd never done that before that we know of, which means it's entirely unpredictable whether she'll target someone else from whom she could profit. And that was my point in saying that all of the character letters and people vouching for the goodness of her character has to be taken in context, because Kacee would have been one of them. She thought she was her best friend until Meggan had something to gain from her, a financial thing to gain from her. And Meggan is backed against a wall here financially, most critically. Her expenses, her house, her car, she doesn't have an ability to easily work, especially if she's on home confinement. Her parents are taking out loans. She's unpredictable when she's backed into a corner. She's, was financially dishonest in a previous job. I think she has established a history of doing that. So back to your question, I don't think that there are conditions that would at least make me comfortable enough for her to be released. But minimally, I would ask, if the court is inclined to release her, I would ask for a bail to be established. I would ask for a protective order to be signed on behalf of Kylie and her husband, who's Kacee's sister and brother-in-law, so that she can't contact them. But honestly, I don't think any conditions are sufficient to ensure against what the state is concerned of here. Certainly, there's nothing that the court could do to meaningfully enforce her not obstructing justice further or getting rid of evidence, as we've demonstrated at the preliminary hearing that she's already done. So unless the court has further questions, that's my position on that.
Thank you. I don't. Anything else, Mr. Williams?
Only if Your Honor is concerned or wants to know information about finances. I'm honestly a bit disturbed about them having investigated my client's family and know about loans and things. I can tell you, Judge, that as an officer of the court, I've been working with this family, and I can commit to you that they will have and do have the services. And I'll just commit right here in open court that I'll do this for free if I have to and see this through the end. You have any questions about the resources otherwise? I mean, we didn't know that the state has been seeking this information. I do know there are resources, and of course, if I were not to be maintained as counsel, she would have the right to a lawyer, and she would have a qualified lawyer appointed by Your Honor. So, yeah, they've had to take a hit to defend her. That's why she's going to stay and defend herself.
Thank you. Counsel, thank you for your arguments today. They've been helpful. I understand the serious nature of the request being made, and I also understand the delicate nature of it also. I'm going to take this matter under advisement.
All right, let's bring in our guest. Joining us still to discuss, criminal defense attorney, former prosecutor Marsha Minot. All right, so you saw there the judge taking it under advisement. Seems like the defense attorney's arguments maybe had some effect. It was interesting. It creates quite a contrast in my mind. What we learned is that there were maybe over 100 character references or letters sent to the court on behalf of Meggan Sundwall. Obviously, lots of folks in the courtroom there to support her. Her family's obviously supporting her. But yet what she did was so heinous to me, Marsha. What she did was she fooled a friend, at least according to the evidence and the information in the case. From December of 2019, there were over 28,000 texts where she spends time trying to convince this woman that she has cancer and convinces her family that she has cancer, terminal cancer. And then she makes her agree to take this insulin, which then would allow her to collect some money. I mean, that to me is scary that someone could do that kind of thing. Anyway, again, it creates really this sense of contrast. What are your thoughts on how this judge might look at this case?
I think bond is going to be denied, and only because, remember, a judge is an elected official, Michael, and in his jurisdiction, he does not want to be seen as soft on crime. These are egregious allegations. If you actually befriended someone and tried to convince them mentally that they were ill so that you could get them to consume some type of product so that they would die, so you could collect from their insurance, that is the most heinous acts that you could ever allege. However, we live in the United States of America, and someone is innocent until proven guilty in a court of law. So this is the problem with trying cases now, is that once the allegations are made against you, before one jury is sworn, before one scintilla of evidence is presented, it is more likely that human beings are believing that you have done what the state alleges. So the judge has a balancing act here. And unfortunately, I think bond is going to be denied because most judges err on the side of caution and will deny bond at the gate. Now, she might get a bond eventually, depending on how long this case takes to be adjudicated, but I think it's more likely it's going to be denied based on the allegations and the state's statements of what happened at the preliminary hearing.
And you are right, Marcia Minot. The judge actually did come back a short time later and decided that he would deny bond in this particular case. There were no conditions that he felt would keep the community safe, et cetera, et cetera. At least part of this whole thing has to do with the seriousness of the crime, but also the evidence as it exists, right? The strength of the case. And if you have strong evidence, I understand what you're saying. You're innocent to proving guilty. Got to prove it beyond a reasonable doubt. But at the end of the day, at this phase, you know, strong evidence in a case suggestive of guilt is enough to keep you on bond.
It is. A court gets to look at the seriousness of the charge. The law allows the judge to look at that and say, hey, I have to worry about the community, not just the person who was deceased, not just your family members or your friends, but I have to worry about other individuals that you may come in contact with. So I'm of the belief, though, that we can balance that. And with technology these days, we can balance it even better than we could back in the day. So I am not so concerned that they could not keep a track on this young lady, especially if she has absolutely no criminal history, to make sure that her constitutional rights are protected at the exact same time that you're protecting the community away from her with these egregious charges.
Yeah, fair enough. Homebound or not, I think she's scary and dangerous regardless.